Welcome everyone to our webinar on engaging contractors, the latest employment law changes. My name is Joel Hayden and I'm a practice leader in LegalVision's employment team, and my co-host this morning is Eleanor Kenny, who's a lawyer in our firm. Before we get into our webinar, there are just a couple of quick housekeeping items to tick off. And so you will receive a copy of the recording and slides today in your email following the webinar, so no need to be taking notes. You can submit your questions that you have throughout the webinar in the chat box provided, and we'll try to get to as many of them as we can at the end and get them answered. We'll also be providing a form for feedback at the end of the webinar, and we do really appreciate your feedback so we can make these as appropriate as possible for the attendees. So we would love it if you complete that as well. For the next 48 hours, you will also be eligible for a free consultation with LegalVision to discuss how we can help your business. So if you do want to take us up on that, please just provide your contact details in the survey at the end of the webinar. So today, we will be discussing some of the upcoming amendments to the Fair Work Act, which will take effect on 26 August 2024. And this is under the Closing Loopholes Bill, the second round of changes provided. Specifically, we'll be looking at the new statutory definition of employment, which will affect the proper classification of your workers as employees or contractors, and some other related changes involving the Fair Work Commission's ability to deal with unfair contract terms. We will be covering off the historical approach to making the determination of when a worker is actually a contractor and how this has changed over time, as well as what the position will be moving forward from 26 August. The potential impact the amendment will have on your business and workforce and how you should approach classification of your workers, and the practical steps every company should take at the moment to ensure that it will be compliant with the new laws once they come into effect a bit later this year. We'll then have some time at the end of the webinar to answer any questions that have already been submitted, as well as any that do come through the course of the presentation. So do keep submitting them throughout. I'll now pass over to Ellie to get us underway.
Thanks, Joel. Let's start by understanding the context for the upcoming amendments. Historically, the employer-contractor question was determined by courts applying a multifactorial approach. This required a holistic consideration of all formal and practical aspects of the relationship between the parties, including but not limited to whether the company exercises or has the right to exercise control over the manner in which the individual works, including their place of work and working hours, whether the individual performs the same or similar services for others, whether the worker provides and maintains the relevant tools or equipment, whether work can be delegated or subcontracted, and whether the individual is integrated into the business or is presented as such. For example, if the worker is required to wear a company logo. In applying the multifactorial approach, the courts would not find any one factor determinative in classifying workers. However, the factors that tended to have the most significance were the level of control the company exercised over how and when work was performed, and how feasible it was that the worker was functionally running their own business and capable of generating their own goodwill in the provision of the services, rather than that goodwill simply attaching to the principal. For example, the High Court of Australia issued several decisions where the fact that the workers provided their own tools and equipment did not actually hold significant weight because the tools could be used in the worker's personal life and were not inherently indicative that the contractor had obtained those items in the course of running their own business. These cases indicated that the primary consideration is whether all factors lend themselves toward the position that the worker was capable of functionally controlling and running their own business. Whilst the courts certainly had regard for the terms of any written contract between the parties, the practical reality of the relationship was equally as significant in determining whether an employment relationship existed, and it was not good enough for the relationship to simply carry the label of contracting. In 2022, the High Court of Australia issued two significant cases, CFMEU and Personnel Contracting Proprietary Limited, and ZG Operations Australia Proprietary Limited and JAMSEC. These cases resulted in a substantial change in the approach of courts to the employee-contractor question. They, in fact, flipped the prior position on its head, as the court determined that where a written comprehensive contract existed between the parties that was not a sham or otherwise ineffective, the rights and obligations under the contract were determinative as opposed to the subsequent behaviour of the parties. This meant that the multifactorial approach used historically was only relevant in the context of the assessment of the terms of the written contract. That is, the same factors were to be considered, however, they were only considered in relation to the contractual terms. The provisions in a contract that were considered relevant to determining the nature of the relationship between the parties included remuneration, the provision and maintenance of equipment, hours of work, provision for holidays, deduction of income tax, delegation of work, and the right to exercise direction and control. The existence of a contractual right to control the activities of the worker, including how, where, and when work was performed, was a major signifier of an employment relationship. It was also determined that the label or characterization of the relationship in the agreement was not relevant to the determination, meaning that simply including a statement that the relationship was one of a contractor and principal was not to be used as a tiebreaker test. In short, these cases provided that the historical approach of considering the totality of the reality of the relationship was now largely confined to the terms of the written contract between the parties, a quite substantial change. To illustrate this, personnel contracting involved an individual who worked for a labour hire agency as a labourer. The relevant contract stated the worker was an independent contractor. However, the worker argued that the nature of the relationship was one of employment. Despite the label the parties had given the relationship in the written agreement, the court came to the conclusion that the worker was in reality an employee, on the basis that the terms of the contract indicated that the company had the right of control over the worker and their work product. The worker had a fixed amount of remuneration rather than being paid for a specific task, and the proposition that the worker was carrying on his own business was untenable. In JAMSEC, 2 truck drivers who were previously employees of the company were made redundant and separately engaged as independent contractors via partnerships with their respective wives. The 2 drivers contended that whilst their contracts stated that they were independent contractors, the relationship itself was indicative of an employment relationship. Applying and approving the approach in personnel contracting, the High Court of Australia determined that the 2 drivers were independent contractors due to the invoicing and pay structure of the partnership, the supply and maintenance of the trucks by the workers themselves, and the flexibility built into the contracts, which diminished the company's control over the workers. From 2022 onwards, the approach provided in these cases to look exclusively at the terms of any written agreement between the parties has been broadly adopted. This approach created a much narrower test and has allowed companies to utilise well-drafted contractor agreements to ensure that their workers are appropriately classified, a much simpler and safer standard to address than the concept of assessing the reality of the situation.
Thank you for that rundown on the historic position, Ellie. And now we'll address those upcoming amendments to the Fair Work Act. And so those amendments that are made under the second part of the Closing Loopholes Bill will again change the approach to assessing whether a worker is in fact a contractor or employee by law. And it's actually a return to a position closer to before the decisions in JAMSEC and personnel contracting that Ellie just mentioned. And so from 26 August 2024, the Fair Work Act will provide a new test for determining whether an individual is really an employee, where consideration must be given to ascertaining the real substance, practical reality, and true nature of the relationship between the parties in determining whether, in fact, an employment relationship exists. This is obviously a big step away from just considering the terms of the contract between the worker and the business, and is a far more complex task. When making this determination, the amendment provides that the totality of the relationship between the parties must be considered, and while regard must be had for the terms of the contract itself governing the relationship, other factors such as how the contract is performed in practice will be relevant. This is a clear deviation from those previously mentioned High Court cases, and it's a much broader test whereby there'll be a need to address all aspects of the relationship rather than just considering whether there's a good, wholesome contract in place and really trying to determine whether the relationship itself fits within the ordinary meanings of an employee and an employer. Beyond providing this new statutory definition of employment, the amendment also includes a somewhat complex opt-out notification system whereby contractors can provide notice to the company that they are electing for the new test to not apply to their arrangement where they earn above a still unspecified contractor high income threshold. Now, this threshold is still yet to be set by regulations, and therefore it's difficult to say at this stage whether certain workers will be eligible to opt out, but it can probably be expected to be around the employee high income threshold currently in place, which is about $170,000 in annual earnings a year. Under the amendments to the Act, where a company believes that a contractor earns above the contractor high income threshold and will likely be considered to be an employee under the amendment, the company may give written notice to their contractors that they are eligible to opt out of the amendment if they wish to do so. And to be clear, that's still the choice of the contractor themselves. That notification by the company then needs to be followed by the actual notice of opting out by the contractor themselves. The uncertainty around this concept of opting out is that the decision itself can be revoked at any time by the contractor. And so it is unclear to what extent this could or even should be relied upon by a company. Where an opt-out notice is in effect, the amendment will not apply to the relationship, and instead, the previous test provided in JAM-SEC and personal contracting will be applicable, i.e. the more simple contract-focused test. This, in theory, could give a company some comfort that well-paid contractors who provide this notice won't be captured by the new provisions of the Act. But again, where this notice can be revoked, it is uncertain how reliable this will be in practice. The amendment has also introduced a new ability for the Fair Work Commission to make orders in relation to unfair contract terms in independent contractor agreements. And this new power for the Commission only relates to contractor agreements, not employment agreements. The Commission can only make an order where it is satisfied that the contract contains one or more unfair contract terms, which in an employment relationship would relate to workplace relations matters. And so what falls within being a workplace relation matter will include things like remuneration, leave entitlements, hours of work, and termination of contract, but will not include other matters like superannuation, workers' compensation, work health and safety, and taxation, which have a broader application than just to employment relationships. The Commission must take into account fairness between the parties when making a decision and determining what kind of orders to make in relation to a potentially unfair term. And when determining whether a contract term itself is unfair, the Commission will take into account a number of factors, including the bargaining power of the parties to the contract, whether there is a significant imbalance between the rights and obligations of the parties under that contract, whether the term itself is reasonably necessary to protect any legitimate interests of either party, whether the term imposes a harsh, unjust, or unreasonable requirement, and whether the fees for the services provided by the contractor are less than regulated workers or employees performing the same or similar work, which could be, for example, under a relevant modern award that would apply if they were an employee. Where a term is considered unfair, the Commission may order that the term be set aside in whole. That means it simply won't apply under the contract anymore, but the rest of the contract will stay in place, or that the term itself be varied within the contract in some way to make it fair. While there's no ability for the Commission to apply financial penalties or reward compensation under these new provisions, where an order is made by the Commission and contravened by one of the parties, this may attract civil penalties. Importantly, a contractor who earns above the contractor high income threshold is not eligible to bring such a claim in the Fair Work Commission. Now, I'll pass back to Ellie, who'll give us a bit of a rundown of the potential impact of those amendments to the Act.
Thanks, Joel. So we'll move on to the impact that these amendments will have on businesses. The inclusion of a statutory definition of employment shows an obvious intention to create a stricter test when determining whether a worker is a contractor or employee. No longer will it be sufficient to have a well-drafted contractor agreement in place that accurately reflects a contractor relationship. Instead, all practical aspects of the relationship will be relevant to the courts when coming to a decision as to what the relationship reflects in reality. The result of the amendments post-JAMSEC is such that where a contractor is not eligible to or does not willingly opt out of the new amendments, companies will have to carefully consider whether there are any aspects of the relationship that would indicate that an employment relationship exists, keeping in mind specifically whether there are any aspects of the relationship that would indicate that the company is exercising significant control over how and when work is performed by the contractor, and whether it is clear on the facts that the contractor is running its own business and is capable of generating goodwill in the provision of the services. Where a worker believes that they may have been misclassified as a contractor, they may sue the company on the basis that they were functionally acting as an employee for the entirety or a portion of the engagement. Should the courts agree that the company has misclassified the worker, they may order that the company make a back payment of employee entitlements, including any underpayment of wages or leave entitlements the worker would have accrued as an employee. Accordingly, there may be corresponding civil penalties applied to the company for various contraventions of the Fair Work Act, including financial penalties for breaching various modern award provisions that should have applied to the worker, or failing to meet general employer obligations, such as providing the worker with payslips. The courts may also issue civil penalties where it is found that the company and any knowingly involved individuals did not reasonably believe that the worker was acting in the capacity of an independent contractor. When determining whether the company had a reasonable belief that the worker was in fact a contractor, the courts must have regard for the size and nature of the employer's enterprise and any other matters the courts determine to be relevant. These considerations will often include the industry the organization operates in, and whether legal advice was obtained by the business regarding the classification of the worker. Whilst superannuation legislation does provide a distinctly different definition of employee, typically workers will make an accompanying claim in relation to the underpayment of superannuation entitlements, where they believe that they were functionally acting as an employee of the business. Further, once the contractor high income threshold is actually established, it will be essential to determine whether a business's contractors will fall below or above such threshold and consider whether it will be appropriate to issue a notice to the contractor to inform them of their ability to opt out of the new amendments and the extent to which the opt-out notice can be relied upon in practice. Legitimate contractors who earn below the contractor high income threshold will now be able to bring claims against principals for terms that are considered unfair contract terms in the Fair Work Commission. Historically, these matters were not within the Fair Work Commission's jurisdiction, and the primary avenue for independent contractors to dispute certain terms in their agreements was under the Australian consumer law, where the relationship met the requirements of the unfair contract term regime. Therefore, this amendment will provide independent contractors with more accessibility to dispute certain contract terms. There was historically another avenue for independent contractors to dispute the fairness or harshness of their agreement in accordance with the Independent Contractor Act. Importantly, this legislation appears to grant very similar avenues to dispute a contractor agreement as the Fair Work Act will as of the 26th of August. Yet it is quite uncommon to see a contractor raise such a claim. The rarity of these claims would appear to indicate that this course of action is not very appealing to contractors, likely on the basis that there is no ability to seek financial compensation for a breach of the Act itself. The amendments to the Fair Work Act specifically provide that the Independent Contractor Act will similarly be amended in August of 2024, so that going forward, only contractors earning below the contractor high income threshold will have the ability to make these claims. Therefore, contractors earning below the high income threshold will now have the ability to bring a claim regarding any unfair contract terms in the Fair Work Commission or the Federal Court of Australia. The relevant terms to look out for in your contractor agreements that may be considered unfair contract terms include, but are not limited to, one-way or excessive indemnities, unbalanced rights to terminate the contract, an ability for the principal to vary the upfront price payable under the contract without giving the other party the right to terminate the agreement, or otherwise, where the contractor is paid less than what an employee would be required to make in that position under a relevant modern award or other applicable legislation. Of course, when considering whether any of those clauses are unfair, the courts will look at the contract in its totality and consider whether they are reasonably necessary to protect the company's legitimate interests. On that basis, there may be situations where a particularly favourable clause is considered fair, having regard to all of the circumstances. Where a contractor files a claim in the Fair Work Commission, this will likely first result in a conference between the parties, and where it cannot be resolved, may proceed to a hearing. Importantly, even where the Fair Work Commission finds that a contract term is unfair, there is no ability for the courts to order financial compensation or civil penalties against the principal. Instead, they will only be able to order that the term be struck out or varied. Therefore, as I mentioned earlier, making a claim of this nature will not be a particularly attractive option to contractors, as there will be no financial compensation for a company's breach of any provisions of the Act. This is certainly evident in the lack of claims that we see filed in the Federal Court of Australia under the Independent Contractor Act. On this basis, it is more likely that contractors will opt to simply negotiate the terms of their agreements as necessary.
So let's move on now to some practical steps that businesses should take to ensure compliance with the new amendments. And these are steps that should be taken prior to 26 August when they kick in. Firstly, it's necessary to perform a stock take of how many contractors you have on board and what the nature of those engagements are to have an understanding of the extent to which these amendments will be applicable to your business. It's completely possible that some businesses did not dramatically change their approach to contracting in response to personnel contracting and JAMSAC, given those decisions are relatively recent. And those companies may still be assessing their contractors on the basis of the totality of the relationship itself beyond the contract. Those businesses will likely be in a better position to deal with these changes than those who shifted to relying primarily on the contract itself. Businesses should then perform a review of the risk level associated with each contractor in relation to whether they are functionally acting as an employee and the likelihood that they will be captured by the new amendment. This should be carried out on a much more strict basis than in the past couple of years, and some of the key factors to consider are the contractor's hours prescriptive? Are there strict policies and guidelines that must be followed when performing the services? Does the contractor perform the same or similar services for other businesses? Is the contractor qualified and experienced in providing the relevant services? And do they relate to a specific trade or qualification? Does the contractor have the ability to negotiate their pay? And is it higher than equivalent modern award wages than if they were an employee? Do they hold their own relevant insurances? And is payment to the contractor subject to PAYG withholding? Overall, a business should be assessing whether the individual is functionally able to be characterized as operating their own business and building their own goodwill in that business, in consideration of their overall integration into the principal's own business. Importantly, this assessment needs to be carried out with an actual understanding of how the services are being provided in reality, and so will require actual knowledge of the day-to-day relationship. It won't be good enough to just look at the contractor agreement itself and say, this clearly outlines obligations that relate to a contractor and a principal. There'll really need to be an assessment of the day-to-day reality of that relationship. Obviously, where a business relies extensively on the use of contractors to carry out its business, consideration of risk in those relationships becomes even more important, as it will be even more vital to the ongoing viability of the business itself. It can then be determined whether the contractors earn above the contractor high income threshold and whether the business would like to notify contractors they may opt out of the amendment. This figure should be prescribed by the Fair Work regulations some point prior to the commencement of the amendment in August 2024. As mentioned a bit earlier, while this route should be considered, it is still uncertain to what degree this should be relied upon, given the worker may effectively choose to opt back into the statutory definition. A formal review of any contractor agreements used by the business should be undertaken, first to ensure that they are supportive generally of the person being a contractor, i.e. not being ambiguous on the written terms that it might be a relationship of employment, and then from the perspective of whether they are unfair contract terms, unfair contract terms contained within the agreement itself that may need to be remedied. It will be necessary to consider any relevant terms in the context of the whole agreement and whether any particularly favourable terms in the business's favour are reasonably necessary to protect the company's legitimate interests and so would have a basis to continue to be included in the contract. Businesses should also consider whether there are any steps they should take in relation to their contracting practices generally to ensure the relationship is supportive of the worker's classification. And this could include steps like requiring contractors to be responsible for their own tax affairs like PAYG, having them hold appropriate insurances for the type of work that they are undertaking rather than being covered under the principal's insurance policies. And also ensuring that work practices reflect a worker who has some separation from the business and that they are not just functionally performing the same duties employees are. Finally, businesses should be aware that while this change is being implemented under the Fair Work Act, this won't displace the definition of employment contained in other legislation, such as under superannuation and tax laws, and those will still need to be treated as separate matters. And so to really summarize what we've been trying to communicate this morning, it's that this is a stricter approach to who will be considered an employee under the Fair Work Act. And so there is a real need for businesses to audit their approach to who they have been classifying as contractors over the last couple of years. So that does conclude the main part of our webinar. You might find our publication on employment essentials useful, and that can be downloaded from the slide you can see on the screen now. You might also be interested in our upcoming webinar on mastering workplace safety, and that's on at 11 a.m. on 11 July, and you can register for that through the link provided on the slide. We're going to get to questions very shortly, and while those are being submitted, we'll take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business's usual legal needs. And it's like having your own in-house counsel. Our team can assist you with unlimited document drafting and review of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more beyond that. We also offer a dedicated service for in-house teams and general counsel to manage your high-volume business as usual legal needs. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. To learn more about those memberships, you can request a free consultation with us when the survey appears at the end of this webinar. And now we'll answer some of your questions. Before I get Ellie to start working through the questions that have been submitted, to answer a common question that has been popping up around superannuation, the test for whether a worker is entitled to superannuation is separate to whether the individual is an employee for the purposes of the Fair Work Act. The superannuation legislation captures workers beyond employees, and the primary part of the relevant test is whether the individual is working under a contract where they are wholly or principally providing their labour to another party. This includes both physical and mental labour. It's not just labour in the physical sense. And there are a number of specific exclusions and inclusions that may be relevant and that are quite complex. Superannuation as an area is also actually advised on by tax specialists. So that's tax lawyers and accountants. And it's quite possible that a contractor will be entitled to superannuation. If there is any doubt whether that is the case in your business, you should absolutely seek advice from a tax specialist, noting that we do actually have a tax team within LegalVision as well. So that's something we can absolutely assist with. And so now we'll move on to having Ellie ask some of the questions that have been submitted both prior and during that webinar this morning.
Thanks, Joel. I will note that we do have quite a few questions coming through, so we'll do our best to get through as many as we can. Going to start with, what are the benefits of contracting versus the benefits of employing individuals?
Yeah, and it's not so much a concept of what the benefits are one way or another, given what we're talking about, that it's about the true nature of the relationship. So it's not necessarily a decision that a business should be making to say, oh, it's going to be more beneficial to engage someone as a contractor because then they're not entitled to annual leave and paid personal leave under the Fair Work Act, because that's exactly what these amendments to the Act are trying to avoid. So broadly speaking, it's much more important to ask what's the reality of the relationship rather than what is more beneficial. But the obvious answer here is that when someone is an employee, there are more rights that that individual will have under the Fair Work Act and associated legislation. So I mentioned paid leave, like annual leave and personal leave. There's then, the other entitlements under the national employment standards, like flexible working arrangements and unpaid parental leave. There's also state-based entitlements like long service leave that apply mainly to an employee. And so is it more admin heavy having an employee rather than a contractor? Usually, but still the question should really be not what the benefit is to the company, it's what's the reality of that relationship itself. Otherwise, you can get in, potentially sticky situations like Ellie mentioned earlier, where if a contractor who's not really a contractor becomes a bit annoyed at the end of an engagement, they will pursue you potentially for things like wages, annual leave, personal leave, etc. And there can also be related penalties, not just for the company, but any knowingly involved individuals. So a real focus on, is this person really an employee, or are they actually a contractor operating their own business? That's the more important question there.
Right. Another one's come through. What are the relevant considerations for the contracting of international freelance subject matter experts for long-term roles?
So there is the potential for a worker outside of Australia to be captured by the Fair Work Act. The general principles we've been talking about today are still applicable in the circumstances, but practically there is probably a little bit less risk where you're engaging someone outside of the country, given they may have less of an understanding of how to pursue their rights through Australian commissions and tribunals and courts, and also being a subject matter expert. That can be quite helpful in the proper classification of someone as a contractor. It's much easier for someone providing unskilled labor to paint themselves as being an employee in reality than someone who's sophisticated and providing specialist advice. So you can absolutely form a legitimate contracting relationship with a subject matter expert outside of the country, even for long-term roles. You just be focusing on the same principles we've been discussing, that they should still functionally have some separation from your business and be building their own goodwill in the work that they are doing. And where someone is paid, well, in the way that subject matter experts often are, that often does practically reduce the risk that they would make a claim regardless. It also means that practically they're probably not going to be underpaid on a minimum wage basis, but they may still be able to claim entitlements like annual leave, for example. And so it is important to still ensure those classifications make sense.
Absolutely. We've had a couple of questions come through regarding non-solicitation and non-compete clauses, and how those, when included in a contractor agreement, are going to interact with those new UCT regime in the Fair Work Commission.
Yeah, and It's a common question, and restraints can be included in all contracts, but it is about ensuring that they are reasonable in the circumstances and don't go further than they need to protect your business's legitimate interests. And so it goes both ways, really, that in the same way, for example, in a labour hire situation, you might not want your own client to be poaching your employees you're placing with them. In the services agreement with that client, you can have non-solicitation style restraints that would also be relevant to contractors. That's absolutely fine and could be a very easy, legitimate business interest to identify. Similarly, you could have non-compete style terms with your contractors to ensure that they don't start providing services directly to your clients. You would just need to be a bit more careful in those circumstances to ensure that you aren't going further than you reasonably need to protect that interest. And so the narrower that non-compete is, the more likely it is to be enforceable, noting that non-competes are very hard to enforce in Australian courts.
Another more specific question come through. Currently, dentists are operating as contractors within this specific individual's private practice. Can you please advise if and when this might change?
Yeah, so again, it's not a concept of this changing specifically for any specific class of contractors. It's about having to broadly assess whether they actually should be an employee. And we're aware that in a lot of medical fields like dentistry, it's quite common to have a professional acting as a contractor rather than employee. And so really, again, it's about not just making sure that you have the contract in place that represents one of contracting rather than employment, a relationship of contracting, then making sure that there is a degree of separation outside of that, i.e. not being prescriptive with the hours that the dentist is working, more compensating them on, a patient-by-patient basis rather than time involved with that patient. Otherwise ensuring that they have responsibility to manage their own tax affairs, ensuring they are the ones that are bearing risk and ensuring themselves in relation to the work that they are doing. And as long as you have enough of those supportive factors in place that you get to a point that it indicates that this dentist or whichever professional is operating their own business, that can be, quite perfectly fine as a contracting arrangement, but you still do need to work through the principles that we've discussed today. But in light of the fact that, dentists, doctors, etc., they're more sophisticated individuals, usually they will understand the relationship they're entering, and the fact that, it's an extremely skilled, qualified area, it does make contracting more acceptable on the face of it than, say, unskilled or blue collar areas where someone's just providing, for example, physical labor. So again, this won't change specifically for any individual dentist, for example. You will still need to apply that general test where the statutory definition is in play.
Had another one come through regarding if the independent contractor has an ACN, so an Australian company number, but acts through a key person, whether that indicates more of a contractor or an employee relationship.
So there's often a need in the contractual terms with a contractor, even where they're engaging you through a proprietary limited company, to have a key person provision to ensure that the person that you wanted to perform the services is actually performing them. And that's the point of the key person provision. If you don't care who on an individual basis is actually performing the services, you wouldn't have that in there or shouldn't have that in there. And so having a proprietary limited company in place, it is helpful and supportive of a classification as a contractor, but it isn't completely determinative. And so yes, it's good to have one in place. There's no specific issue with having a key person noted under the agreement itself with the entity that will be performing the duties. But again, it's not wholly determinative. And so it wouldn't be the only question that gets asked, say, if there was a dispute about the proper classification. There would still be a broad assessment of the reality of the relationship itself.
Had another one come through, similar vein in terms of how much weight would be placed on any particular factor. But if a contractor were, or an individual were to come to the business and specifically request that they be engaged on a contractor basis, what kind of weight does that hold in the decision under the new Fair Work amendments?
So it will definitely be considered by a court in the event that a dispute arose, in that the more that the parties to the contract understand the distinction between employing themselves and contracting themselves, that is helpful to speak to the reality of the relationship, because intention is somewhat relevant. It's not solely relevant, but it is somewhat relevant. And a lot of the cases, pre and post JAMSEC and personnel contracting, the courts did actually quite closely consider, was this something that the worker themselves was actually agreeing to consciously, i.e. were they aware of the difference between an employee and a contractor, and did they agree to be a contractor? And of course, the reason workers sometimes request to become a contractor is that there can often be benefits in the form of potential tax benefits, a lower marginal rate of tax, and that's often why that request pops up. And of course, a court would have consideration for that in saying that, in being a contractor, the individual has received a benefit consciously that's more akin with someone who would be operating a business, and that's definitely relevant.
Does the term contractor apply to third-party contractors? For example, if we're contracting through a recruitment agency, do these changes apply?
It all depends on whether you are contracting them directly or not. So if it's labor hire, in the sense that someone else is the party with the legal relationship with the contractor, and they are just providing that contractor to you as a client to perform work on your behalf, the real risk lies between the labor hire provider and the contractor themselves, because that's where there is actually that services agreement in place. When there will be the risk that we have been talking about today is when the legal relationship exists between your business and the contractor themselves, rather than that, intermediary labor hire provider. So if it's recruitment, generally that would be providing or sourcing the worker for your business, and then you engage that worker. If that's the case, then there is this potential risk that we've been talking about.
Great. In a similar vein again around how much weight would be placed on any factor, if a client were to pay contractors annual leave and sick leave, would those contractors be considered an employee?
That is a big risk, and that was even a risk prior to these amendments kicking in that personnel contracting JAMSEC, that made the court's focus really on the contract itself and any factors that could indicate employment or contracting one way or the other. And so when we talk about paid annual leave, paid personal leave, they are entitlements under the Fair Work Act. It's also possible for someone to contractually provide that to an individual. But if you are providing a contractor with that type of annual leave and paid personal leave, it makes even the contract itself look like one of employment. And so that would be an issue right now, and will obviously continue to be an issue post the amendments as it gets more strict. So that's the type of thing you would want to avoid providing to contractors, because it really makes them look like an employee.
Absolutely. So throughout the presentation today, we mentioned how the amendments to the Fair Work Act will impact how companies have been classifying their contractors over the past couple of years. We've had a question come through about whether this legislation will apply retrospectively.
It's not going to apply retrospectively in relation to an employee being a contractor, being able to go back and rely on the statutory definition retrospectively. But we do still need to be aware that that previous common law position is still relevant, in that they could assert on a common law basis they have been a contractor the whole time, or been an employee the whole time. But that statutory definition will only kick into effect on 26 August.
Had a question come through whether it's okay to provide supervision or support to a contractor, even if they are fully qualified.
It again has to be part of the global assessment of what that contractor is doing. There's nothing wrong with providing some support, some level of, supervision, as you would see in a lot of true business to business services agreements, but you would not want them to be entirely under the direction and control of another employee of the business, because that really reflects more of an employment relationship rather than any other type of contracting relationship.
Great. We've had another one come through around how should they go about determining a contractor's capabilities to functionally run their own business? So what are the relevant factors under that broad category?
It's a lot of what we've been talking about today. And the way that I like to summarize it is it actually possible for the individual to be building goodwill in themselves or the business that they are operating? If they are literally holding themselves out at all times to just be an emanation, is the way the courts describe it, of the principal company, it's very difficult then to say that they are operating their own business. So even putting aside things like, a higher level of skill, providing their own tools, having their own insurance and paying their own taxes, the key, aspect that really needs to be able to be shown is that they are actually building goodwill, because otherwise they are really just integrated within your own business and not running their own distinct business to that.
Absolutely. Had another one come through about how to determine if a contractor has reached the high income threshold, given that contractors ordinarily have numerous sources of income, which the company wouldn't necessarily have any transparency about.
And we still need to see how this is specifically going to be communicated into the regulations for how that is going to be calculated. Typically we should expect this to really be about the contractor and the amounts they are receiving on an annual basis from the principal themselves. It's completely correct that you're not going to be able to understand what that contractor is receiving from other companies. If they were actually, working for other companies on a basis that was ongoing, multiple other clients, they're likely to not be captured by that definition of employment anyway. And so really at this stage, we should be thinking about this as contractors you're solely engaging who are earning above 170,000-ish from your business rather than from alternative businesses. But again, we really need to have that clarified by how that comes through into the regulations a bit closer to those amendments kicking in.
Absolutely. So unfortunately, that's all that we have time for today. We apologize if we haven't been able to get to your question. Please do submit your details in the survey following the webinar today for assistance with questions that we weren't able to get to, and to learn more about how our membership can assist you and your business. While this is a free webinar, we do really value your feedback. So please do complete the 30-second survey that should appear in just a moment. And thanks so much, everyone, for joining us today.